Hello, everyone. Welcome back to another episode of Banking Matters. I'm your host, Daniel Baker. Joining us today, we have William Huttenbach, or Pat for short, who is a litigation attorney concentrating on civil matters at Crain, Caton James PC. He has been a bank litigator for over 25 years and is the former chair of the SWABC. He is the current chair for the committee in Texas that proposes revisions to the UCC and other banking laws. He gets asked to be an expert witness on issues concerning UCC Sections 3, 4, and 4A. He has filed or answered over 335 lawsuits involving UCC Sections 3, 4, and or 4A issues. He has also personally answered over 2,000 garnishment lawsuits. Pat has written numerous articles on banking topics and has given speeches to the banking industry on how to better protect banks in litigation through updated deposit agreements. Pat, welcome to the episode.
Well, thank you for having me.
So, Pat, I'd like to start first by asking all of my guests, what is it that got you involved in banking? So I know you're not directly involved in banking because you're an attorney, but what is it that got you involved in banking litigation?
Well, I was selling Cutco knives in Charleston. I was running a Cutco knife selling office in Charleston, South Carolina. I was a victim of armed robbery, and that encouraged me to go to law school, having to be a star witness in a case. So I turned lemonade from lemons, and in law school, I did not want to be a lawyer. Actually, after my first year of law school, I'd done really well and did not clerk anywhere. But my second year of law school, I clerked for a judge and said, you know what? I actually could see myself, being a litigator, and then really liked the UCC banking laws, and I've just been doing it for 20, 25, 26 years now.
Well, that's fantastic. That's a little bit of transition, though, from Cutco to law school. I bet that was a fun and interesting situation.
I love it. The Cutco knives really made me a good litigator, because they talk about handling objections, and you have to plan your own time, and
Yeah.
I owe a lot of my legal success to Cutco. It was great.
As a kid, I used to take this little white box with me to school in middle school, and I used to fill it up just with random stuff I could find in my house, and I used to call it my box of junk, and I would sell it to other kids at school. So I can definitely appreciate and understand some of the elements of having a sales background and learning how to overcome objections and everything like that can definitely benefit an attorney. So, Pat, you've got a lot of experience in the UCC, which is great because the UCC can be really kind of complicated and convoluted if you don't really understand what you're looking at there. What kind of cases do you usually litigate around that? What's usually crossing your desk?
So when I started, 25, 26 years ago, they said that we would not have very many check cases in 10 or 15 years.
Mm-hmm.
And over the last year, that has exploded. So
Yeah.
there is a whole bunch of altered versus counterfeit check cases. Wire transfer fraud is booming. All sorts of, bank fraud is booming right now. I've taken 2 cases to the Texas Supreme Court in the last 5-6 years. One that came out in 2022. So, but I'm happy to share some of my details of that stuff with you.
Yeah, that would be great. What cases have those been, or what has really stemmed from those?
So the seminal case used to be the American Airlines v. Martin case on 4406 issues, which is an issue that bank customers have to timely report unauthorized disbursements out of their bank account.
Right.
And so if you're a bank customer and you don't look at your bank account under the UCC, you have 1 year to timely report an unauthorized check or item.
Mm-hmm.
The American Airlines lowered that to 60 days. I represented Compass Bank in the Kalaja case that came out, I think, 2018, and that confirmed that banks can make statement availables to customers, that issue under the UCC, and also confirmed that the bank deposit agreement in dispute was a 30-day requirement.
Mm-hmm.
So that's one of the cases I've held, and that's kind of the 2 big cases in Texas on 4406 issues. Another case that just came out, I guess, in 2022 was the Elizondo case, which was an attorney got tricked into depositing a counterfeit cashier's check and then got tricked into wire transferring the money to Japan. And so who's liable for that? And the attorney said the bank is. I represented Cadence Bank in the Supreme Court, threw out a lot of his arguments and said, no, he would be responsible for that wire. So unless some affirmative defense is applied. But that actually a case is just got granted the summary judgment in the trial court and might be going to either trial or up on a court of appeals in the near future. So that one's still ongoing, but that's a counterfeit check case.
Well, that's a huge one because I mean counterfeit checks in the industry. I mean, you can correct me if I'm mistaken, but just drastically increasing over the past few years, right?
Yeah, a lot of people get tricked into depositing checks. My dad gets letters every couple weeks, or not maybe not week, every couple months, saying that he's won Publishers Clearinghouse or he's won this,
Hmm.
and the scams a lot of times revolve around, hey, you got to pay some fees to get a big bunch of money, or we'll send you a check, and then oops, they send a different, much bigger check, and then ask you to wire transfer the money back. So there's just a lot of types of bank fraud going on right now.
So I mean, banks are getting hit with these checks that are all sorts of values, right? So they're not always large dollar checks. A lot of times they're small dollar checks like 10, 20, $30, maybe a couple $100, all the way up to the point that I'm sure you'd get involved, which is maybe some of the bigger checks. At what point do you usually see banks turning towards a litigation attorney to get involved in these processes?
Well, one of the biggest things I'm seeing right now is that um, customers will tell the bank, "Hey, I didn't write this check, or the check I wrote has been altered, and the payee has been changed." There's a huge problem with mail fraud right now, and
Yeah.
so I will help banks make a claim against the depository bank, saying, "Hey, look, you accepted a altered check. You need to return the money." Um, and so that's where banks can get someone like me involved. I gave a speech at a Louisiana Banking Association conference, and there's another panelist with me, and he showed people how you can buy post office uniforms, actually the post office boxes themselves.
Hmm.
The fraudsters are just going nuts to intercept the mail. Earlier this year, the USPS actually announced or recommended you don't mail paper checks in the mail anymore because it has just gotten so bad.
So bad.
And
Interesting.
so those are the types of situations where customer reports the fraud to the bank, and the bank says, "Well, I think this is an altered check because they put the check in the mail as intercepted." And so I help the banks make a demand upon another bank on the UCC transfer presentment warranties.
So walk me through that process then. So bank reaches out to you and said, "Hey, we've got this check that's been deposited, et cetera, et cetera." What's the first step of their interaction with you? What does that process look like of making that demand? What are we looking at?
So the first time the check is presented to the bank, the bank has 24 hours to pay or not
Hmm.
pay that check. And so that's considered finally paid under Reg CC. But even if it's finally paid, a bank still has transfer presentment warranties that are owed
Hmm.
to it. So, and those warranties are that including that the person who deposited the check is a person authorized to enforce the instrument, that all the signatures on the or endorsements on the instrument are valid. Another UCC transfer presentment warranty is the check is not altered. And so if that check was intercepted in the mail and the payee or the amount was altered, then if you're the maker's bank and your customers complained, you have a claim against the depository bank.
Hmm.
Uh, there's a big issue that's arisen in the last 5 years, but that's the type of situation I'm getting involved with quite frequently right now.
Okay. And then do you see a lot of arguments from banks saying that, hey, look, I shouldn't be liable for this when maybe they should be liable from it? Do you see a lot of that?
A lot of the big banks have come back and said these are not counterfeit, these are not altered checks, they're counterfeit checks.
Okay.
And the problem is a lot of people don't know for certain whether it's truly counterfeit or altered because that fraudster could take that check and in the old days they'd use whiteout and they'd scratch off the
Right.
you know,
It was clear and evident.
exactly. But now they have special pens that can remove ink. They
Yeah.
have special solutions they can dip the check in. So did the fraudster dip that same piece of paper and then reprint on that piece of paper? It's very difficult to tell whether or not it's a counterfeit or an altered check. And so, if the depository bank says, "Oh no, these are counterfeit checks," they say that's the other bank's fault. So that's the big fight: is are they altered or are they counterfeit? and there's a couple weapons you can use to try to win that battle.
So let's talk about that. What in the UCC, what is really, for our listeners, what is really the difference between counterfeit and altered?
It's a blurry line. And it's something that the drafters of the UCC are going to have to address at some point,
Mm-hmm.
because whether a fraudster, dips that piece of paper in the solution and reprints on that same piece of paper, that's generally considered altered. If
Okay.
they find all the information on a check and scan the information off and reprint on a new piece of paper, that's generally considered counterfeit. And
Right.
so, what the fraudster does that apparently under the laws that exist today, that determines whether or not a bank, the depository bank's liable or the maker's bank is liable. And so, some people think that should be changed because, should the bank be opening up an account under suspicious circumstances? Should a bank be allowing a large, unusual deposit, usually into a new account, or, if it's a relatively old account, even a few months old, and there's a few minor transactions, all of a sudden, boom, a $10,000 or
Mm-hmm.
$100,000 deposit, and then a wire transfer to Japan. Why aren't banks picking up on that? So those are all issues that we're going to have to address in the next couple of years.
Right. And obviously a lot of that's going to be through the UCC state law and case law, right?
Yeah, and the big what we've been trying to do recently in Texas is get the new Article 12 passed. That's
Okay.
been the big that's kind of the virtual currency, those types of issues, and it's not virtual currency, but it's to address some of the updates that need to be done. So, but that's the big change in the UCC that's trying to get pushed through all 50 states right now. That's a
Perfect.
new Article
So if I'm understanding correctly then, counterfeit checks is really where you have a new check completely created in some way, shape, or form, where they may take the information from an existing check, but effectively it's a new check. An altered check is something that's already been written, like the amount, signature, the whole shebang, and then they change something about it. Is that a fair summary of those two items?
Yes, and then there's all sorts of stuff in between, because what
Of
happens if
course.
they're retracing,
Yeah.
or so then you got a forged maker signature, but you also got a forged endorsement, you got a double forgery situation. So the law is just getting more and more, a lot of blurred lines
Yeah.
as the law is evolving. So.
So then how can a bank become proficient in this? So maybe this isn't necessarily your area of expertise, but how would you encourage a bank to maybe learn more about the UCC, so when they come to you, they have a greater idea of what's already going on before they even get to your doorstep?
So there's not a lot of lawyers out there that are doing what I do.
Okay.
I usually listen to my current clients, and I represent, I don't know, 60 banks now, 70 banks now,
Right.
and credit unions. And so what they have been asking me to do, and I think I've run it the last 3 years, or maybe for the last 5 years, I kind of lose track. But last summer, I did a 6 hour, three 2 hour sessions, bank fraud update. And we went through check fraud, went through wire fraud, even added Zelle fraud for the first time this year. I had a section on Zelle fraud. And so, but I actually go into, banks and train their fraud teams. I help develop the forms, whether it's the new fraud affidavits, hold harmless agreement issues. You need a fraud team that knows the law, and I
Hmm.
can give you one example of that.
Yeah, please.
So one of the best things a bank can do in this type of situation is, because it's so hard to tell whether it's counterfeit or altered. If you're the maker's bank and the depository bank pushes back and says we think it's counterfeit, you can demand to inspect the original check. And there's a
Okay.
Reg C provision that says if they do not produce the original check, it's presumed to be an altered check. So
Huh.
if the other bank says, I'm not going to pay, I think it's counterfeit, well, then say, well, show me the original check. And if they can't produce the original check, it's presumed to be altered. But a lot of the banks that I work with, if they haven't been to my fraud trainings or something like that, unfortunately, they don't know those types of tricks to be
Right.
able to effectuate a recovery. So.
Well, I feel like so many of these larger institutions, primarily the larger ones, from my experience, is that when they receive a demand letter or something like that for payment, they just automatically, like it's almost like a default. They almost start automatically rejecting it, and then you have to go back and fight it with them to kind of get the payment. Do you see that a lot?
Um, yes and no. I'm trying to be nice. Here's the problem. I was speaking to an in-house counsel at a big bank,
Uh-huh.
and there's a couple that are now notorious for just not responding or canned response that later turns out not to be completely accurate. But I was speaking with an in-house lawyer at a big bank who I've known for a long time, is a good person, and he said we're getting like 18 to 20,000 claims a month, and they just cannot
Wow.
keep up
Yeah,
with it. So
there's no way to stay on top of that. Yeah.
so to be fair to them, when there's that much, my response to that, because I usually represent, not the biggest banks in the land, but my response to that is that, well, then you need to be more careful in opening up those accounts and making sure that the deposits are not altered. So there's a lot of people complaining about big banks, and I represent a few big banks, but it's a tough issue out there.
So then let me ask then. So you get to a situation where someone's not responding, or bank's not responding to the demand. Then what comes next? Is it do you start the process of filing? Are you sending another letter? What happens after that point?
So after my fraud training this summer, I had several banks come to me and say, "Can you develop a set of demand letters that we can send to the bank?" And,
Right.
and those demand letters is the sentence, "Please send me the original check for inspection," because
Right.
that's something that the bank should do. And then even, and you pointed out earlier, there's an economic issue that you don't want to have me write a letter on a $200 or $1,000 check.
Right.
But let's say you get a couple $3,000 checks, and I can bundle them up and write a demand letter for the bank and say, look, hey, we got 10,000 bucks for the checks here, or 100,000 or whatever. So
Yeah.
you just need to be the squeaky wheel. But even then, they, sometimes that demand letter gets, lost somewhere. So
Yeah.
you might not get a response. So.
So after that point, then is when you look at considering like the process of filing and everything like that.
Correct. You have up to 3 years to bring a transfer,
Right.
presentment, warranty claim. So even if the prior demands have gone unanswered and it's been 8 months or a year, you still have up to 3 years under the UCC to bring a transfer presentment claim.
So that's a great transition because I'd love to also pick your brain a little bit about the UCC. And I know that honestly, we could probably spend all day talking about the UCC and the intricacies of UCC. But do you have like two or three nuggets that you're like, I like this element, like the request to receive the original check so you can verify it or you can inspect it. Do you have two or three other nuggets from the UCC that you just really like or are your favorite elements of it?
Well, I'll give you a couple. You need to have good internal forms, whether it's a good deposit agreement, whether it's good fraud affidavits. You need to have good forms, because if you've got the right provisions in there, and a lot of smaller banks, I'll defer to the big banks. They actually do this one really right. A lot of times they have
Mhm.
strong, powerful deposit agreements or
Yeah.
treasury management agreements or wire agreements. They really need it, because they'll cover 98, 99% of what could happen over the next 5, 10 years.
Right.
Smaller banks, I see them still using a lot of the 5 page or the 10 page or the 15 page deposit agreements, and you'll have so many things that come up, and you're like, oh, our deposit agreement doesn't cover it, and just basic stuff. And so
Yeah.
I would really look at your internal forms. You want to have good fraud affidavits. Even specialty forms, like what happens if a customer doesn't want to close their account after bank fraud. First of all, that's just crazy. They got to. I mean, that their bank fraud information is known by a fraudster,
Yeah.
and you
I
think the
mean, why
fraudster.
wouldn't you?
It's crazy. So to answer your question, some nuggets: ask for the original check for inspection, have good bank forms, and then have a system where you have good follow up. And so you send the demand letter, you don't get a response in 30 days or whatever. I like to send a response after 10 days or 14 days, and be the squeaky wheel. You still might not ultimately get paid, but a lot of times you do, because the bank doesn't want to litigate. So those are some things that most banks should be doing more of, and then training their fraud team. A lot of the fraud team, they pull from other areas of the bank. because they're so in demand right now, and they might not know the UCC, and so there's plenty of training opportunities out there to help get them trained up.
I love that. Those are great topics, and those are great little nuggets. Well, Pat, before we completely wrap up here, I wanted to ask kind of one additional question of if you could give a piece of advice to banks today. So to those who are listening in or tuning in, we usually focus on small, mid-size, but really we're open to anyone. So if you could give a piece of advice to any of our listeners today, what would it be?
You never know what the future is going to hold. I mean, I'm supposed to be a dinosaur because they told me that check fraud was going away and I was going to pivot. And then I got, into the 4A issues and the wire fraud issues and now Zelle fraud issues and stuff. But it's amazing, the banks that we're even having this conversation that check fraud has really just exploded. So, you need to have a team, a fraud team that can focus on the basic types of fraud. And then also have a fraud team that really can. I mean, we just touched on the basics, but do you have an imposter rule situation? Do you have a UCC 3405 employee responsibility defense? There are so many defenses that you can raise to save your bank money, and if you don't have that training, then you might just be paying out on claims that you shouldn't be paying. So I guess that's a big thing. Is it's such a compartmentalized stuff, but just as need people with good regulatory advice, you need people on the fraud side too to help protect the bank. So
yeah, because I mean, ultimately, the more fraud you prevent, or the more fraud that you get paid on, the less of a loss the bank or its customers are taking.
Exactly, and the customer doesn't understand that the bank that they've got a loss and they're asking the bank, please repay this loss, but the bank doesn't have a bucket of money sitting in a vault that's their money. This is going to be a direct loss to the bank. And if the customer truly caused it, if they weren't looking at their statements every month, or they let an employee get access to blank check stock, that really should be on the customer. Or if you can push it off to, another bank that they truly caused it by opening up a bad account. But if you have the right people trained with that type of stuff, you might save the bank, 50, 100, or hundreds of thousands of dollars. So.
Yeah, I completely agree with that. Well, Pat, thank you very much for joining us for today's episode. It's been a pleasure speaking with you about the UCC and check fraud and bank fraud.
I hope we got people to go right to sleep.
Well, I'm sure that we at least engaged some of them. For the rest of you listening in, that's Banking Matters.